You want to start? Okay,
Yes.
then I guess. You know the rules, right? 20 minutes.
Yes,
And you want some rebuttal time up to 5 minutes?
I would like to, I would like to
5 minutes?
reserve.
All right, I'll let you know.
Yes, thank you. May I start?
Yes, sir.
Good morning, your honorable judges and members of the channel. Good morning, everyone. Further, I'd like to thank you for extending me the privilege to be here in front of you today. My name is Radu Krejcin. I'm a pro-se litigant in this appeal today. The appeal case number 2D213005.
Do you mind speaking up a little bit louder? Because when you put your head down, I can't hear you.
I'm sorry.
Maybe it's me, but it could be the microphone.
Could be, yes. I might need to stay closer to it. Again, my name is Radu Krejcin. I'm a pro-se appellant in this case matter today. Appellate case number 2D213005. Honorable Court, first I want to draw your attention to the fact that Ms. Rusu and her filings of this appeal, she has concentrated her efforts in the entire 35 pages of her answer brief to attack my character and to make numerous unfounded allegations and insults against me. And she took another 10 pages and her motion to dismiss my appeal to do the same, instead of staying with the facts in this case if she had anything truthfully to say. So, in the due course of my oral arguments, if time allows, I'm going to answer her false allegations and insults. Honorable judges, I strongly believe that based on the laws of this state and based on the precedent of the appeals court of this state, I presented strong arguments in my briefs that the lower court committed error after error in this case matter, entering ex parte emergency order on August 4, 2021, to alter the provisions of the final judgment. Further, not scheduling a timely hearing on my motion to dissolve the emergency order. And further, holding a return hearing that was not timely noted. And at the time, the court was aware that after August 20th, I was infected with COVID and under the powerful medications, which was remdesivir. I took the shots of remdesivir and brought me back to life. My mind potentially, my mind didn't alter by the medications and by the illness. More, talking about the return hearing didn't have anything to do with any emergencies or any best interest of the minor child, as we can read in the order. That return hearing, my belief is that was strictly about just setting me up and discussions about the car incident 6 months prior, as one can simply understand reading the order on return hearing entered on September 9, 2021, and subject to this appeal. Nonetheless, Ms. Russo's emergency motion to suspend father time sharing that she filed on August 4 failed to outline any immediate irreparable harm to the minor child or any risk of the minor child being removed from the state, because there was none. As one can read in Ms. Russo's emergency motion. Also, her emergency motion failed the certification to what efforts have been made to contact me for the hearing, or otherwise state why I should not be contacted for the hearing. And I can list some cases, similar cases, as Hunter versus Hunter and so on. But by the virtue of time being very limited, I'm going to move on. Even more, Honorable Court, I rightfully invoked res judicata on this appeal, as Ms. Russo had no contact with me for over 10 years since we separated in 2012. I'm not her drinking buddy, and she doesn't know any true facts about my life since we divorced. On page 5 of her answer brief, she's fantasizing something might have occurred in 2009 of my life. Even she fantasizes to something 21 years ago on page 13, about half page under the argument of her answer brief. In 2009, even 21 years before she filed her emergency motion, as she argues as she argues in her answer brief. I believe she didn't even know that I exist and where do I exist. At the time, I believe she was living in an ex-Soviet Union republic. Now, by my experience visiting those republics, some of those republics, Soviet Union republics, I know how they tell the truth, and the people here, how they tell the truth, and what they think about America. And my belief is that Ms. Russo inherited a love to gossip, and she found audience in the lower court in Denmark. Since we divorced, Ms. Russo hardly could ever see me from a distance. During the exchanges at the police station, when we do the exchanges during my visit with my son, and we do the exchanges at the police station for the very reason to protect myself against the avalanche of false allegations and assaults. In over 3 years, I didn't even talk to her. Even during court proceedings, we were under COVID restrictions and we were doing Zoom. To make a story short, a legal question of law: how can possibly Ms. Russo claim all the insults and allegations she made towards me are true if she never had contact with me in all those years? I didn't talk to her over 3 years. She's not around me, and I never had a drink together with her for that matter in over 10 years. She never filed any motions claiming that I abandoned my child, nor my motions that the child was ever abused by me, as she falsely claims not in her answer brief and her motion to dismiss my appeal. To answer these questions, this question of law is that Ms. Russo perjured herself, and I believe perjury does come with the provisions.
Mr. Crescion,
Yes,
you were at the hearing where that resulted in the order that's on appeal. Is that right?
we were through Zoom.
Through Zoom.
Yes,
And did you tell the trial judge then that you were suffering from COVID or that you were on medicine?
I did more than that. I sent 2 emails to
Before the hearing?
before the hearing and after the hearing as well. There are 2 emails. I have evidence of the emails sent to the court.
The emails that I've seen in our records seem to have been after the hearing. And so that my question was, what did you do before the hearing?
If my memory helps me, I did notify the court before the hearing. And during the hearing, I did state my position, and I was not offered the opportunity.
And unfortunately, we don't have a transcript of that hearing.
Right,
You know that,
unfortunately,
right?
yes, we do. We do not, by the fact that I was going to get a court reporter, and the hearing was not timely noted. And the premier of being able to hire a court reporter, and also I have those emails to report to the reporters to set up. If I'm wrong, if the emails or if the email that I'm referring to was after the hearing, but for certain during the hearing I did make my position, and I was not offered this opportunity. The only opportunity I was offered during the hearing was to enter a fifth, because they were beating me or beating the horse, excuse me for my expression, on the whatever happened to 6 months prior to that incident, which this case is not about that incident. It's strictly about a minor child that his rights have been abused. And I believe the lower court committed error after error in this case matter, as I presented in my briefs. If I may continue, the second legal question of law is how my child was affected by the fact that I was involved in the fender bender accident beyond my control. While the mother admits that my child was not present, and I never missed any visit with my child following that incident, the answer to that question is that no one was affected, including my child. The entire motion, emergency motion, was based solely that I was involved in some sort of accident 6 months prior to the filing of the emergency motion, where basically the car was taken as a deadly weapon by overzealous cop. And that's another story. Now, Ms. Russo, she waited 6 months after the incident to file her emergency motion. And it would only make sense, she could have waited for a regular scheduled hearing if she believed she had a case. What was her emergency? I explained extensively in my briefs that there was no emergency, as outlined in Gershon versus persons. We do have on file the record and the attachment to her emergency motion, claim as verification. The record of the incident she referred to 6 months prior to her filing of emergency motion. The record is a public record nonetheless. And I didn't see anyone saying anything about mental issues or alcohol issues or any handguns. However, her so-called verification does not equal affidavit, the affidavit required by the laws of the state to contact me for emergency motion hearing, or otherwise state why I should not be notified of the hearing. She never logged any complaints that I'm aware of whatsoever to authorities or to court that I might be criminal, drunk, mentally incapacitated, impulsive anger, or otherwise that I have ever displayed any sort of mental or physical abuse towards her or towards my son Alexander, or displaying any weapons whatsoever, as she falsely claims on page 25 of her answer brief. I ought to believe I would have been arrested if any of the above would have occurred, and with no doubt she would have told this honorable court about my arrest. I'm going to skip some paragraphs I have here, and I might come back to that. Nonetheless, this case today, it is not about any fender benders incidents. It is not about any handguns or cannons. In this case today, it is not about any belts, as Ms. Rustos refers in paragraph 9 of her motion to dismiss my appeal. Rather, this case here today is about a minor child, that his sacred rights have been abused, his visits with his father got unreasonable suspended, and in fact, this case is about an error of the lower court that is to be corrected. And Ms. Russo's bells, as she refers in page 9 of her motion to dismiss, will be honored here in this honorable court. My visits with my child needs to be restored as soon as the discretion of this honorable court dictates, at the minimum as per final judgment. As now the summer break is coming up, I would kindly ask your honorable judges to order a make-up time for the visits lost between August 4th and May 11th, 2022. As follows: 41 dinner visits lost for 3 hours each week, totaling 123 hours of dinner visits lost, and 20 weekends visits lost from Friday 3 p.m. to Monday 7 a.m., equaling 64 hours each visit. I added them together, I came up with a total of 1,403 hours, which translates to 58 days and 11 hours. This is the total days I have lost visiting with my child based on the mother fictions. I would suggest that during the summer break, my child stays with me and the visits with the mother, and he visits with his mother in the reverse order as my visits were. In other words, every other weekend and every Wednesday, until we catch up with the time. After that, we go back to the regular time sharing as per final judgment, whereas the further modifications calls for. I believe this is a fair schedule and serve the best interest of my child. Now, if the time allows me, I'm going to tell you a little bit about me. On the contrary to her filings, to her insults and allegations, false allegations. One thing she's not telling you what I do in my life, that I'm an active member in good standings of Romanian Orthodox Church, Clearwater, where my child is visible every Sunday, he is with me. She's not telling you this fact because she doesn't know any true facts about my life after I divorced her. And my son is not telling her what we do together. And because Ms. Russo doesn't know anything about my life after I divorced, she's making up untruths, and her imagination runs wild. Bringing insults on page 26 of her answer brief, and I can start with some people are inherited bed, whatever she's trimming out there. Now, just reading next paragraph on her page 26, she's telling us what her intentions are, and she's telling this court, this is an emergency situation that can be cured once and forever. Full and complete termination of father visitation rights with minor child, except for telephonic communications initiated by the minor child. Ms. Russo, in fact, is telling us what she hides behind these false allegations. She's asking this honorable court to set aside the law and abuse my child's sacred rights.
You're coming up to your 5 minutes. Do you want to keep going or you want to save the 5 minutes?
I'm going to save my 5 minutes.
All right, we'll save it for you.
Thank you, Your Honor.
Ma'am, you want to argue?
I don't have anything to add.
Nothing
Just
to add,
my
okay.
information.
You got your 5 minutes.
Yes,
Keep going.
thank you. Honorable report. Basically, what Ms. Russo is asking this court to give her my child, so he further gets punished with and not having any contact with me. Even during the phone conversation, the phone visits with my child, the only thing my child is coached to tell me, I don't want to talk to you. And that's what he has been telling me for approximately 2 years now. I have provided my child 4 phones over the years, but he cannot use them because mother takes them away because he talks to me. He's using the phone to talk to me. Another report, my child only spent 1 week in his 11 years of life visiting with me for extended period of time, which was 1 week by the virtue of Honorable Judge Henson that has extended his kindness, and he put trust in me, and I took my child to the Smoky Mountains. Otherwise, during the weekend visits, we hardly can reach Miami on very rare occasions. At no time the mother ever logged any complaints following this case. Honorable Judges, Ms. Russo's suspicions worries me a lot. And at the same time, at the time when she's contemplating suicide and murder, and she has custody of my son, that worries me a lot. Honorable Judges, I can assure you I'm not mentally incapacitated in any way. And she is admitting in page 5, 6, and 13 of her answer brief. I have never been found mentally incapacitated, I'm not suicidal, and I have no intentions to harm anyone. I want to assure you, I have no alcohol issues. On the contrary to her allegations, I do not use any alcohol at all. In fact, I inject myself 5 insulin injections every single day. And I wear a monitor, the monitor just turned down a little bit, and I had to put the kid in my mouth. My sugar running low. So I'm injecting myself insulin because I want to live. I don't want to die. And I want to carry on my duties as a loving father for all my children, and I want to see my children grow up. I don't use any alcohol as opposed to when I was married to Ms. Russo. My 32 years since I live in America, I never had any DUIs, I never used any illegal drugs in my entire life. I never have been found mentally incapacitated in any form. I never used a gun against anyone. And I was never been convicted of any wrongdoings in 32 years I live in this wonderful country. My criminal record is crystal clear. Honorable Court, you have today in front of you a 56 years old man and a loving father who takes pride in all his children. More, I am a loving father to all my children equally, wherever they are, including the 4th child that I have adopted from Morgan, previous marriage. The child has witnessed the death of his ill natural father. And based on my stepson sharing with me, I don't wish any children on this planet to ever experience such departure and separation from his father.
You got about a minute left, so you know, so choose your last minute the way you want.
Honorable Court, I would like to introduce to you my wife, Olga. Please stand up. I'm married to her for 7 years, no problem, no issues. Other than what Ms. Russo is making up. I want to emphasize that Ms. Russo emergency motion that she filed is not supported by any facts and not supported by any laws of the state. She admits on page 8 of her answer brief that the minor child was happily visiting with me at the time she asked the court to suspend my visits. And even after she was empowered with an order suspending my visits, she allowed the visits to continue. And I returned my son happily living to the mother, as always. She failed to make any reference to her in her emergency motion of any immediate irreparable harm to the child because there was none.
I don't want to interrupt you, but you're out of time, so.
Thank you, Your Honor.
I want to thank you for coming. Thank you for coming.
Thank you, Your Honor.
Hope you both have a nice day. We're going to call the next case. That's John Shim, MD versus Cruz and Chronister Sheriff of Hillsborough.